Hi, I'm Shan Wu with an Undercolor of Law hot take on misunderstandings about the separation of powers and how that phrase is being abused. So to dive into this a little bit, I'm going to talk about two, at first, somewhat unrelated items in the news. One's an opinion piece, one's a news item, and then tie it together a little bit for you about the constitutional issues. So first, retired Judge Nancy Gertner had a piece in the New York Times, and we'll put up the screenshot for you. It's entitled, "What Judges Can Do for the Rule of Law Under Trump." And so in this piece, she talks about how judges need to view their roles a little bit differently in the upcoming regime than before. Basically, what she's saying is they can't rely upon a now unreliable system. We'll put up a full shot of some of the text here. I just want to summarize and maybe read through a little bit of it for you, because she gives some good examples, so take a look at it here. She says, as an example, suppose a federal district judge is asked to sign off on an eavesdropping warrant under Title III of the federal criminal law. The judge receives a one-sided, that's called ex parte submission, meaning they only hear from one side. In criminal law, it tends to be ex parte from the prosecution asking for the warrant, and they will consider this without cross-exam, without the defense counsel presenting anything, because the defense counsel doesn't know about it yet, may not have been hired. She says, in previous administrations, federal trial judges have had generally well-founded confidence that the Justice Department under post-Hoover and presidents from either party have not been employed to attack political enemies. Most district judges, especially those who've served as federal prosecutors, as most have, believe that the prosecutors appearing before them act with integrity, that their officers are not being manipulated, and a judge can assume that such a warrant has gone through layers of approval within the Justice Department, even reaching the Assistant Attorney General in charge of the criminal division, an extremely high-ranking official. The judge could also be reasonably confident that very little, if anything, would be amiss after going through all these layers of approval. That's the end of the quote there. So this is a very forthcoming admission by Judge Gertner, a very respected judge of great integrity and wisdom. But it's very forthcoming because it talks about the sorts of assumptions that courts make. And it's the assumptions that are actually kind of misplaced. Great that she's saying, hey, quit making these assumptions. But first of all, some of those very high-profile decisions go even higher than the Assistant Attorney General. I mean, they go all the way up to the AG or the Deputy AG. I know because I used to be there to give recommendations on whether they should sign off on very sensitive issues like that. But what's wrong about the assumption isn't that it necessarily goes up through those layers. What's wrong about the assumption is the courts always, doesn't matter what administration is, they need to make inquiries about the evidence about the probable cause, what justification is there for the investigation and warrants, no more than what the law requires. But what the judge is really warning against here is the idea that courts can rely on just the representations made by the prosecution, sort of a good faith assumption as she speaks to, instead of relying upon scrutiny of the evidence presented to them. Now, it's a lot of courts that do this, and you're going to see that if they were beginning to push back, it could slow things down a little bit. I'll give you an example of that. In most preliminary hearings, that's way past this point of warrants. A lot of times, the defense counsel waive the preliminary hearings. The judges tend to want to waive them as well. Now, defense counsel may waive it for various reasons. They may not want publicity about it. They don't know enough yet to do a cross-examination. But courts tend to want to waive them too for purposes of being efficient. They don't want to be bogged down in like dozens of preliminary hearings. But it might not be a bad idea to think about that tendency to want to be just efficient there and go ahead and press for the hearing to have the government make its case in these probable cause determinations. Same thing, even if it's ex parte, the judge, and they sometimes do this, go back to the prosecution and say, hey, I'm not convinced, show me more, I want some answers here. Maybe even ask a supervisor to come in to speak to the question. Now, what we will hear a lot about, particularly if these courts began pushing back some during the incoming Musk administration, cue the outrage and appeals, trying to get to the Supreme Court arguing that this is some sort of a separation of powers that's going on, that's undermining the president, undermining the Justice Department. There may be calls to remove judges, as well as saying that they are needing to be impeached. And maybe they'll try for something called a writ of mandamus, which is saying that the court's out of bounds and needs to be directed by the higher court to correct something. Now, this brings us to the second news item, which is Associate Justice Clarence Thomas and new revelations about even more undisclosed financial benefits that he got as part of his Friends with Benefits arrangement with people like Harlan Crow. We'll put up a screenshot for you of this new ethics report. We'll make it a big screenshot, as some of you asked for it. It's easier to read. And let me read along with you for just a little bit here. The investigation found that Thomas has accepted gifts and travel from wealthy benefactors worth more than $4.75 million by some estimates since his 1991 confirmation, and failed to disclose much of it. The report goes on to summarize it this way: the number, value, and extravagance of the gifts accepted by Justice Thomas have no comparison in modern American history. Now, it also, this same report, it's worth taking a look at. It's a very nice historical report on all these sorts of benefits that have been taken, not just by Thomas, by others too. Liberal justices have also been given benefits like this, although they tend to have actually disclosed them the way they're supposed to do it. This one also gives us something new about Justice Samuel Alito about a 2008 luxury trip to Alaska. Alito's position was he was exempt from having to disclose the trip under the previous ethical rules. You know, Justice Alito always a stickler for reading the rules and the timelines to which they apply. And we can take a look just to emphasize that quote, put it up again for you. There's no comparison in modern history. It's really quite stunning to make a statement like that about the millions of unreported dollars that Justice Thomas has received. I mean, maybe we have to reach back to earlier centuries where transparency was much harder, no internet, and times like the times that the MAGA Republicans and other authoritarians want to return us to so they can do what they want to do under cover of darkness. So I bring up these two situations because they're united by a likely challenge to them and the sort of likely misuse and misunderstanding, perhaps, of the separation of powers aspect of the Constitution. It's a fundamental misunderstanding, but one that the right tends to just trot out constantly. And so let's summarize it without having to dive deep into the constitutional analysis and historical precedent. Very simply, separation of powers simply means the Constitution establishes three branches of government, and one isn't allowed to do the job of the other. So we've got the legislature, Congress, we've got the judiciary, we've got the executive branch. They're not allowed to do each other's jobs because they're separate branches. But there's this catch-all escape clause when it talks about the establishment of the three branches that says sometimes they can do what appears to be the other's job as long as that action comports with the Constitution, which frankly is a big enough escape clause, catch-all, to drive many, many large trucks through. I mean, that's what allows agencies to make law, right? It's what allows courts to sometimes appoint investigators, presidents to make law through executive orders, and it allows the Supreme Court today to basically control anything they feel like controlling. So let's say it loud and clear. When judges constrain prosecutorial wrongdoing, that's not a separation of powers problem. That is the way the separation of powers is supposed to work. It's an example of it working in action. When a congressional investigation reveals wrongdoing on the part of the judiciary, that's not a separation of powers problem. That's the separation of powers at work, doing the right thing. So when supporters of the current Supreme Court regime and the High Court itself, those justices may say, oh, you can't constrain us, through any, for example, enforceable set of ethics guidelines imposed either by themselves, by their fellow judiciary, albeit lower court judges, or by Congress making a law that could affect the justice's behavior. They want to say, oh, you can't do that. It's a separation of powers. It undermines the court. That's not a separation of powers problem. It's the very fact that they say that is the abuse of the separation of powers. Their very existence today under the present Supreme Court structure, the kind of power they have now that's unchecked, that is the separation of powers violation. They embody it. What can be done? We should keep calling this out to gradually be able to change this tone, to change the conversation, where it becomes much harder for people to just throw this out there and say, oh, can't criticize the court, can't control them. It would violate the separation of powers. Or courts can't stop something wrong from happening because that's a separation of powers violation. We have to change that tone, change that conversation, so it becomes harder for people to make that argument all the time because it's a wrong argument. So that's it for now. A couple of things. Thanks again for your replies and comments. They're really great to read. And I want to share something with you, which is obviously when there are lots of comments, which are great, it's kind of hard to read all of them, impossible to reply to all of them. I really don't get, you'll hear some commentators say, though, I never read comments, I never read replies. That does not make any sense to me. The whole point of this is to talk to you, so we and I want to hear what you have to say. May not always be able to respond to everything. And sure, there are going to be people who are just out to criticize, to be trolls, etc. It's not very hard to see who those people are, okay? So I will try and reply, but I do try and read through as much as I can, as do all of us here, because we actually care about what we're talking about and what you think about it and our engagement. And the last thing I want to add is this is a little farewell to our current studio. We're going to be moving to a different facility. So hopefully it'll look just as good, if not better. But you can say farewell, and I'll say a fond farewell to this studio, which has served us very, very well. All right, talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.